Why did you hire this company to do threat assessment on your two clients? Is that something you do for every client you have?
No.
Why did you find it necessary to do for this particular client?
Well, just the level of threats since all of this began for Ruby and Shay have been quite high. She's been listed on death lists. She's been told that she needs to leave her house by the FBI. So we just need to keep an eye on what's out there, whether there are any spikes or flashes in the threat level. So this company has been retained to do that.
And in fact, the threat levels at one point prior to this matter were so high, she had to relocate from her home.
Absolutely.
And that was on the recommendation of the FBI.
Yes, it was.
Prior to the state contacting you, were you made aware of some comments by a defendant in this case on social media?
Yes, I was.
What defendant were you aware of making comments as it related to your client, Ms. Freeman, prior to the state ever contacting you?
Mr. Harrison Floyd.
How is it that you became aware that Mr. Floyd, the defendant in this matter, was making comments about your client?
Well, a couple of my co-counsel informed me that there were some comments being made and that we needed to huddle together and have a session to assess what was going on and to determine whether there were any measures that needed to be taken by us or by Ms. Freeman and Ms. Moss.
To keep them safe.
To keep them safe, absolutely.
That was Fulton County District Attorney Fani Willis herself conducting the examination in the bond revocation hearing of one of Donald Trump's criminal RICO co-defendants, Harrison Floyd, and I'm Ben Meiselas from the MeidasTouch Network. There was a hearing that was held on Tuesday for the bond revocation of one of Donald Trump's co-defendants, Harrison Floyd, for making multiple statements, many of them threatening statements, on social media directed at witnesses in this case, which would be a violation of the terms of his release. So a motion was filed to revoke his bond by Fulton County District Attorney Fani Willis. A hearing was held to determine if Harrison Floyd, one of Donald Trump's co-defendants in this criminal RICO case, should be immediately remanded into custody. Ultimately, the outcome, and I'm going to show you the moment this went down, and then we're going to discuss why it went down this way, is that Judge Scott McAfee, who I've thought been doing the right thing, been making tough decisions, but been a very law and order judge, ultimately Judge McAfee said that there was a technical violation that was committed of the terms of his release by Harrison Floyd, but that not every technical violation requires an immediate remand into jail, and therefore Judge McAfee did not order that Harrison Floyd go to jail based on a violation of the terms of his bond. Instead, what Judge McAfee ordered was a modification. I'll go through the modifications, but let me explain the broader dynamic of what's going down here. But first, let me play for you the moment where Judge McAfee found, yes, Harrison Floyd engaged in a violation of the terms of his release, but no, he was not going to be remanded into custody, meaning he's not going to get thrown into jail right now. But also, there would have to be a modification of the terms of his release. Let's play that clip.
I do think that in several instances here, there has been a technical violation of Mr. Floyd's bond, and that communications he made wound up before the eyes and ears of potential witnesses and co-defendants. But not every violation compels revocation. And so I am stuck on the question of notice, and that the bond conditions as written in my mind were not specific enough to account for the nuances of social media. So I think the ultimate result of today's hearing is that it's very clear to me that this bond needs to be modified. And I think it needs to specifically prohibit any public comment concerning Ms. Freeman, concerning her daughter, and concerning other witnesses that need to be included because even if he's not directly or indirectly communicating with him, however we define that term, I think the public safety interests raised as a result of today's hearing indicate that his actions have a consequence. And because he's under the conditions of this bond order, the court has the ability to curtail and protect that interest.
And I want to go into why I believe Judge McAfee made that order in a moment. But I want to show you this clip as well, where you had Fulton County District Attorney Fani Willis examining, directing questions at an agent who was assigned to this case, who was explaining the types of threats that was going on, and specifically how the threats that were directed at witnesses were, was very, very, very severe. Here, play this clip.
And at her home via Cobb County PD body cam.
Okay. And are there words in that particular depiction that were not present in State's Exhibit number 11 or 12?
Yes, ma'am, there are.
Will you read into the record what those words are?
Those words state, he told her that he wanted to help me.
Is there a comment beneath that in State's Exhibit number 13?
Underneath, there's a comment from at brunettes. Brunettes are great. And the statement or the comment is Ruby should be in prison with an angry emoji face.
Okay, let's move on to State's number 14. Is what's at the top of State's Exhibit number 14 simply, again, the image of Miss Ruby Freeman?
Yes, ma'am, it is.
And can you please read into, and there's the same text from Harrison Floyd that was displayed before, correct?
That's correct.
In an effort to not use as much time, can you just get us to what the comment is under that one?
The comment from at MS Miss Tish TSH 80 is Ruby the racist. Who would have thunk?
Do you consider those to be positive comments?
Not at all, ma'am.
Let's go to State's Exhibit number 15. Again, the same post from Mr. Floyd. There's an image again. Who is this image of for purposes of the record?
Miss Ruby Freeman.
And are there different words that were displayed on the previous post?
They are the same words. He told her that he wanted to help me. Same words.
In image from the body cam in this case?
That is correct.
And does it display the witness, Ruby Freeman?
It does.
Is that the same Miss Ruby Freeman that is listed 40 times in this indictment?
Yes, ma'am, it is.
All right, so let's talk about the dynamic of what was going down here and why I think Judge McAfee ruled the way he ultimately did. I think on the one hand, Judge McAfee said, look, he didn't actually say this, but here's what he's thinking. Donald Trump is violating the terms of his condition, the terms of his release, and those conditions over and over again. So if you remand into custody immediately, if you throw into prison Harrison Floyd and not Donald Trump, what it would seem to then require right away is if Harrison Floyd was found in violation, that would create the precedent to put Donald Trump in custody right away. And I think what we've seen kind of time and time again are the judges, like whether it's Judge McAfee or even Judge Tanya Chutkin, not wanting to take the bait here, whether it's the bait of Harrison Floyd, the bait of Donald Trump, where it's almost as if they're trying to provoke themselves to be found in violation, placed in custody. Why? To try to delay the proceedings and then to basically have a sideshow where we're no longer talking about the underlying criminal case. We're talking about potential appeals and briefing on the remand of the defendant, whether it's Trump or Harrison Floyd, into custody. And I think these judges have their eye on the prize. And that's not to say the eye on the prize is we need to have this specific outcome, but the eye on the prize is get this case before a jury. That the American people, that the people of Fulton County, Georgia, deserve to have a jury hear these criminal case and it not be derailed, it not be sidetracked, it not be what's going on with Judge Eileen Cannon. And so, ultimately you find a violation here. Before you know it, I think Judge McAfee realizes I'm going to have to put everybody, you know, all of these co-defendants to some extent have engaged in technical violations. And then are we going to turn this case into, however many defendants are left right now? There were 3 or 4 who pled guilty. So let's just say about 15 mini trials about technical violations. And look, the message was sent, though, you know, we're going to modify the terms of your release. And if you violate these terms, you will be remanded into custody. But basically, final warning, let's focus on getting this case to go to trial. And let's not forget, there's a big hearing on December 1st. And Fulton County District Attorney Fani Willis is asking for an August 2024 trial date now that Judge Eileen Cannon didn't move her trial date. One of the big pieces of evidence, by the way, too, that was introduced, I should mention this, was Harrison Floyd responding to MeidasTouch reporting on the Jenna Ellis proffer. Harrison Floyd responded to MeidasTouch, "Wow, at Jenna Ellis, you're a whole mess, girl. So you didn't stop at stealing people's hard-earned money for your defense. I guess they don't teach ethics at Harvard Law anymore." She went to Harvard Law. And then it's he's responding to our reporting here at the MeidasTouch. That was a major piece of evidence right there. Here are the modified terms of release. The key terms that I want to direct your attention to on the modified terms of release is right here, sub 10. The defendant shall make no public statement of any kind concerning any co-defendant or witness in this case, or concerning any person specifically named in the indictment. This shall include, but is not limited to, statements in books, statements in newspapers, statements in magazines, statements on television, statements on radio, podcasts, YouTube, Rumble, or any other commercial or self-published media. And what Scott McAfee said is that that paragraph was not specifically in the other terms of release for Harrison Floyd. Now they're in there. He's got clear notice. He will not hesitate to throw him in jail if he violates these terms, but that's Judge McAfee's way of giving a final warning. And look, we all may be frustrated with this and just saying, look, if this happened in any other context, people would be in jail. And by the way, I agree with you, but I also think that there is a perspective of these cases need to go to trial. I don't think any of us want to see these things being delayed for any significant period of time. Judge McAfee's been moving this case along efficiently. And so, you know, and he's been conducting everything publicly. And so, you know, I ultimately, while I think I disagree with the decision, I respect his decision. That's the decision of a judge. That's what it is. We'll see what happens with the trial date, but you know, that's where we're at right now. Hit subscribe. We're on our way to 2 million subscribers. Check us out at patreon.com/MeidasTouch and have a great day.
Hey, Meidas Mighty, love this report? Continue the conversation by following us on Instagram at MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.